What is the probate process in North Carolina? Hey there, my name is Ron Payne, and I'm the founding partner and managing partner and CEO of Payne Law here in Kernersville, North Carolina, where we practice estate planning, probate, family law, business advising, and residential real estate closings. Today for you, we want to answer the big question, what is probate and what's that process look like in North Carolina? Simply put, probate is the process that you go through in North Carolina when your loved one passes away and you need to take care of their will and their estate. Whether they have a will or not, probate is the process that you go through when you ask the clerk of court to certify who's in charge of everything, and then you gather their assets, pay their bills, and then hopefully can share the love with the family at the end of the process in the form of an inheritance. So the first thing that you've got to do in that whole process is find out if there's a will or not. You may not know, and that's okay. If you don't know, but you think you might know where it's located, but maybe it's in a bank, you go to the courthouse and we apply for that process to appoint somebody as the executor of the estate or the administrator of the estate or personal representative. You hear those terms tossed about, and different ones are used for different processes, but they all mean the same thing. Who's been appointed by the court to represent the decedent in the estate to get this process moving forward. Once they have the will at the courthouse and you file that, if there is one, then the clerk of court validates it, says, yes, this is a valid will. No, it's not. Sometimes there's questions. That's where we come in handy. Then we begin the process of working through the estate. Sometimes you have to post a bond. Sometimes you don't. It just depends on what's going on and if there's a will and if there's instructions in that, and you choose the right kind, and then they appoint the executor. Once they appoint an executor, personal representative, etc., the next step is you receive letters from the clerk of court. These are stamped letters with the official seal of the clerk of court saying you are in fact the person, if that's who's been named, to handle the estate. And you can take those letters, because they're a binding court order, to the bank, to the hospital, to creditors, to other folks, and that way you can gather the information. The most common ones are gathering from the bank. Maybe there's a safe deposit box and you didn't have the authority to get into it right when they passed away. This allows you to get into that. This allows the banks to talk to you and share their private information, etc. The next thing you have to do is open a bank account in the name of the estate. That's where all of the estate money comes in. It is so important, if you open a probate in North Carolina, not to mingle the estate money with your personal money. If you do that, you could end up in a heap of trouble and it causes complications. So always keep the estate money separate. Even if you're the one who's going to inherit it, you always want to keep that separate. So you open a estate bank account just in the name of the estate. We can help you do that. And then you start moving forward. The next thing you've got to do, and of course this is something that we help with as well, but if you're doing it yourself, we file a notice to creditors. And that's what you see in the legal section of the newspaper. If you've ever taken a look at the back of a newspaper, and I realize some of you probably watching this don't get the newspaper anymore, but it's very much still there. It's a legal requirement in North Carolina. You got to publish those notices. And so you'll see in the newspaper, if you look, notice to creditors. Come one, come all. If you have any claims before the estate of such and such, please present them before 90 days from this notice. Otherwise, you don't get to claim anything, basically. And then while that's going on, you find, if you're the executor, you gather all of those assets. You get the house cleaned up if there's a house, especially if it's going to be sold or passed on to other family members. And you gather all of those things. And then during this process, as you go, you submit a 90-day accounting to the clerk of court, which is the initial sort of, here's what I found so far, and then every 1 year thereafter. Once you have all of the bills, the notice of creditors has run, and you have all the bills, and hopefully you found all of the assets by that point, then the next thing we do is determine which bills are valid or invalid, and if they're valid, we pay them. And there's a whole list in the North Carolina General Statutes of what bills have to be paid first and in what order. The executor gets to collect their stipend. If there's an attorney, if there's creditors of the estate, for example, if you had to use a cleanup company to help clean the house, to prepare the house for sale, those are expenses of the estate. So those kind of things are usually paid for at the top. And then, of course, the federal tax man gets his money next. And then after that, the state tax person. And then we get into the different levels of creditors as we go down. Once we've done all of that, all the bills are done, then voila, we can write checks to the heirs of the estate or the beneficiaries or whoever's going to inherit in this case. Once you've done that, The heirs will need to sign a statement saying, I've gotten everything I'm entitled to. Of course, if you want to have your check, you've got to sign for it. The clerk of court wants that proof. They'll also ask for copies of canceled checks, etc. And then all done. Once you're all done with that, you submit a final copy of everything, the checks, the inventory, the final inventory showing that everything's been paid out. So your starting balance starts at 0 when you open the estate. You end at 0 because everything's been dispersed to the family. And then you're complete. So that was just a short, quick roadmap of the estate process in North Carolina. North Carolina, it typically takes anywhere from 6 to 18 months. Usually right now it's on the longer side of that. If it's an intestate estate, which means there was no will, it's going to take even longer because you have to notify all of the heirs before you can even do anything. So you can run the estate, but you've still got to make sure that you notify every and each heir who might be entitled to inherit if there's not a will in place. Of course, the best way to go about that is to have a will in place, or if you want to bypass this probate process entirely, have a trust. All of these are things we can help with. If we can help you avoid the headache, we have clients come to us from time to time and they'll say, I started doing all this myself and I am overwhelmed. I just don't know what to do next. The clerk of court keeps telling me I have to do the following things and I don't know what that means. That's not a problem. We can help you with that. Let us here at Apple Payne Law take that burden off your shoulders. We are pros in dealing with the courthouse. We will take care of the court so you can take care of yourself and your family. Thanks again. If we can be of help with your probate, we can be reached at 336-281-6928. That's 336-281-6928. And again, those consultations with us for probate are absolutely free. We'll go over your situation, determine what the best plan of action, how we can help, what that's going to cost, if anything, out of pocket, depending on where you are in the process, and we'll take that burden off of your shoulders. So check us out on the web at applepaynelaw.com. Give us a call to set up that free consultation. Shoot us an email, or you can always check out more of our content on YouTube. We hope this has been helpful and hope you have a great day.